Okay, welcome to everyone. Good morning, Europe. Good afternoon, Southeast Asia. I am Marta Bettinazzi, and I'm the IPR Business Advisor of the Southeast Asia IPR SME Help Desk, and I'm going to be the moderator for today. But before I introduce you to my expert that I already thank for being here with us, I want to go through some feature of the webinar tool, because we are looking for your input also to a very live discussion. So please be aware that you can chat with us using the chat type place, but you can also ask direct questions that are going to be answered by our speaker today, our expert today, live. However, if you're shy and you don't want to ask a question now, you can always contact us at the end of the webinar if you have more questions. And please notice that everything is going to be recorded, so you will find a recorded webinar plus all the PPTs on our website in the upcoming days. So what is the IPR Help Desk? Why are you here? We are a project, it's an initiative of the European Commission, and we offer one-to-one consultation, so we answer your questions. We also have trainings in person if you are in Southeast Asia, but also in Europe. We have online trainings like this one. But also, if you have seen our website, we have a lot of materials which are easy to understand and done for speaking to companies. So don't be afraid. You can always consult them. And if you have more questions, again, you can ask us. But without any other further ado, let me introduce our expert, Mr. Andrew Diamond, who is a lawyer in the UK, but is also now practicing in Indonesia, and is admitted also. He has also a degree in a degree in Singapore. So thank you, Andrew, to be here today, and I leave you the floor.
Thank you, Marta. My name is Andrew Diamond, and I will be presenting on patent protection in Indonesia. I'm going to start a very quick background about myself. As Marta mentioned, I am a foreign IP consultant at Yanwar Yahya & Partners, which is a boutique intellectual property firm based in Jakarta, Indonesia. I am an American attorney. I have a law degree from Brooklyn Law School, and I'm a member of the New York Bar, but I've been in Indonesia with Yanwar Yahya & Partners for the past 7 years. So before we get too far in, I do want to make sure that everyone has an understanding of where Indonesia is, at least geographically. As you can see from these two maps, Indonesia is spread out east to west. In the heart of Southeast Asia. It's an archipelago of approximately 17,000 islands, about 1,000 of which are inhabited. And it is located with Australia to the south, China, Philippines, and mainland Southeast Asia to the north. And so it really occupies a very strategic location in the heart of Asia. Indonesia is actually the fourth largest population in the world. It currently has about 264 million people, the majority of whom are young, tech-savvy, with increasing amounts of disposable income, which makes it a huge domestic market for lots of different brands, both domestic and what we would call here a foreign brand, so a non-Indonesian brand. It's currently, it is a member of the G20. It's currently the 16th largest economy, but it already is the largest economy in Southeast Asia and is projected to grow and rise up that list to the top 10 by 2050. Last year, the economy here grew at 5.17%, which was the fastest rate in 5 years. And the biggest engine driving that growth is consumer spending, and that constitutes approximately 70% of GDP here. Now, here's a neat little chart that I like to include to show exactly the rise of Indonesia. This is based on GDP in 2012 on the left, where you can see Indonesia at 16th position. And these are based on current projections, but by 2050, it's estimated to rise to the 9th largest economy on a GDP scale, which at that time would be larger than the UK, France, Germany, Canada, Italy. So it would really constitute quite a remarkable rise. Indonesia is also, it's a founding member of ASEAN, which is the Association of Southeast Asian Nations. It is a 10-member state grouping for political and security purposes, and it has tried to fashion itself into more of an economic bloc as well. And so they've introduced a number of measures to kind of make it into sort of a mini EU through the reduction of taxes and tariffs to promote the free flow of goods and services and investment and people. Just a couple of, short snapshots about ASEAN that perhaps you might not be familiar about, but as an economy, it would have been the 6th largest in the world, the 3rd largest in Asia behind China and Japan, I believe. And as by population, more than half of the population is under the age of 30. And it would be the 3rd largest population block in the world. So it's really quite a significant thing on a number of different levels. However, it's not all roses. On the innovation side, Indonesia does suffer from very low rates of research and development, both public and private. This is one of the factors that results in it having the lowest rate of innovation among the G20 economies, which would be based on number of patent filings or grants, as well as publication of scholarly journals. So there's about 8,000 patent applications that are filed coming into Indonesia every year, and there's about 15 applications going out. So that really gives you a sense of the disparity here. And of those 8,000 applications coming into Indonesia, about 90%, of the 8,000 applications that are filed in Indonesia, about 90% are foreign filings coming from outside. More generally, it can be said that it is possibly difficult to do business here, that there's economic uncertainty, corruption is a problem, and there is a potential for political risk. However, the government under the current president, Joko Widodo, commonly known as Jokowi, has been making progress on many of these fronts. And he was just reelected to a 2nd term, which will be running an additional 5 years. And so his focus has been on infrastructure, good governance, and the ease of doing business in order to attract more foreign investment. Turning now to a patent introduction. There's 2 routes for filing patent applications in Indonesia. The first one is the Patent Cooperation Treaty, or PCT. The second one is the Paris Convention. Both of these routes require your home country, that is the country that you first file your patent application in, to be members of one of these treaties or conventions. Whether you choose to file in Indonesia through the PCT route or the Paris Convention, your patent application has to be filed through a local agent in Indonesia that would be registered with the Ministry of Law and Human Rights. If you're going to be using the PCT system, which is essentially just a global administration system to facilitate the filing of patent applications, there is a 31-month deadline in order to file in Indonesia, and that's counting from your earliest priority date. So it's the first date that you file your application in your home country. You have 31 months to file in Indonesia. Now, there is a bit of a grace period, so you can file after the 31-month deadline in Indonesia, but you have to pay a pretty heavy fine of approximately $500 plus professional fees for the agent, and other disbursements. And ultimately, it's up to the discretion of the Patent Office whether to grant your request for late filing. Typically, if you're filing between 31 and 34 months, it will be granted. And after you get past the 34-month period, it becomes increasingly less likely, but it is up to the discretion of the Patent Office. So in order to save costs and headache and to reduce risk, it is highly, highly recommended to mark down that 31-month deadline and to file in Indonesia before. The Paris Convention also has a similar deadline, that's 12 months from the date that you file your application in your home country. However, for the Paris Convention route, there is no grace period, so you must file before that 12-month deadline. For patent applications filed in Indonesia, it's currently taking approximately 3 to 5 years from filing to grant. And I would say that that's a great improvement from the recent past where it was taking at a minimum of 5 years. So from an administrative standpoint, the Indonesian Patent Office has made some very good headway in terms of reducing the amount of time it takes to get a patent through. I think generally we could describe the process for the patent process in Indonesia as follows. There's the filing of the application in Indonesia, which is followed by the formality examination. And that is the examination by the trademark office to check to make sure that all the required formality documents have been submitted. So that would be a signed power of attorney, a signed statement of entitlement by the inventors, a deed of assignment signed by both the inventors and the owner, as well as the Indonesian translation of the specification and the PCT documents, or if you're filing a Paris Convention application, a certified copy of your priority document. So once that all has been examined and checked off, the patent will then proceed to the publication period for 6 months to allow third parties notice that you have applied for a grant of patent related to your invention. Following the publication period and assuming a request for substantive examination is filed, the patent will then proceed to the substantive examination stage, where it will be reviewed substantively by a patent examiner in the Indonesian Patent Office. Following that review, they will issue their first office action, and then assuming that that office action is dealt with satisfactorily, it will then move to the grant stage, and then the patent certificate will be issued, printed, and forwarded on to you. So we reached the first poll question that we have.
Yes. So the poll is going to be launched. So I invite all the attendees to answer the question. We give you, let's say, 30 seconds, 40 seconds to answer, and then we come back and comment the results. Okay, so now we are seeing the results. We have 78% thinks that a patent, a foreign can apply through the Patent Cooperation Treaty and through the Paris Convention but we also have a 22% that thinks that they can file directly to the Indonesia Patent Office. Andrew, do you want to comment, to add something?
Sure. So the most correct answer is D, which would be that a foreign applicant can file a patent application in Indonesia through either A, the Patent Cooperation Treaty, or C, the Paris Convention. Now, directly with the Indonesian Patent Office is only available to Indonesian applicants or people that are only seeking protection in Indonesia itself. However, there are probably restrictions in your home country that would prevent you from being a citizen of that country and filing a patent invention in the first time outside that country. So the technical correct answers are D, through the Patent Cooperation Treaty or the Paris Convention.
Okay, thank you. So we continue the presentation. We close the results. Perfect. So please, Andrew, continue.
Great. So we're going to move on to patent prosecution. And patent prosecution is just a legal term which describes the patent application, examination, and grant process. So when people say this patent is being prosecuted through to grants, or they talk about patent prosecution, all they're doing is talking about the application process. It's just a sort of a fancy legal term that is used. But we're going to talk about some tips and best practices that you can keep in mind with regards to this patent application process that might save you a little bit of time or hopefully some money as well. So for Indonesia, one of the tips is that because formality documents are required to the greatest extent possible in order to meet deadlines, it's suggested or would be recommended to submit all of the formality documents together with the application at the time it's filed. So this would be the signed power of attorney, the signed statement of entitlement, the signed deed of assignment if relevant, the Indonesian translation, and the PCT documents. Those would be ideally filed together with the application, because if they're not, once the application is filed, the Indonesian translation needs to be submitted within 30 days. And the signed formality documents, like the power of attorney I was talking about, statement of entitlement, those need to be submitted within 3 months. There's extensions available for the submission of the signed documents, but oftentimes agents charge for that. They also will charge perhaps for late filing, which would be not filing these documents altogether with the application. So to the extent that you're able to plan for this and gather all the documents beforehand, get all the signatures in advance of the deadline, it can really reduce costs by avoiding extensions or late filing of these documents. So also the next one deals with additional claims. And so many of you might have already looked at a patent specification before, which is what we call the entire patent document, which includes the abstract, the description, the figures, the detailing of the problem that this invention seeks to solve. And so within that, you have patent claims. And so, you know, they're numbered, claim 1, 2, 3, and so on. Indonesia starts, well, for filing in Indonesia, your first 10 claims are free, or let's say they're included in the filing fee. But for claims 11 onwards, you get charged an official fee at the time of filing. And oftentimes agents will also charge a professional fee for each of these additional claims above number 10. So they'll charge you for 11, 12, so on, each claim. So if you're able to reduce the number of claims so that it's below or at 10, you can avoid those official fees. And the way to do that is to amend your specification and amend your claim set to reduce the number of total claims. And that will avoid the payment of these official fees at the time you're filing the application. If you do it after the application has been filed, you've already paid the official fee claims and that money is not refundable. So this is really only applicable if you're able to amend your specification and reduce the total number of claims before you file in Indonesia. Translation is another issue, and it's another place where people run into costs because specifications must be filed in the local language, which is Bahasa Indonesia. Translation errors are common, and sometimes the translation are often too literal, so they lose their specific meaning. Other times, you know, figures are mislabeled or pages are missing. So again, to the extent that there's time, it would be recommended to ask your local agent to send you back the translation the Indonesian translation before filing. And you can just take a read through and make sure that all the paragraphs line up, that there's the right number of paragraphs, that there's the right number of claims, that the figures haven't been mislabeled, just sort of basic things like that. And I think you might be surprised at how often you would catch one or two errors that might otherwise be quite detrimental. And again, linking back to what I just mentioned about reducing the amount of claims, the claims also have to be translated as well. So if you're reducing your total number of claims from 25 down to 10, that might be a few extra pages that don't have to be translated, which would allow you to save on costs there. Okay, so now we're moving on to the point in the patent prosecution process where your application has been filed, the formality requirements have been met, it's been published, and you've already filed a request for substantive examination. Now that request for substantive examination is due to be filed 36 months from your international filing date, if you're using the PCT system, or 36 months from the Paris Convention date. So those are things that you need to be confirming, those deadlines you need to be confirming with your local agent. You need to be calendaring them, but your local agent should also be calendaring them as well and reminding you that you need to be filing this request. If you do not file the request for substantive examination, your patent will be considered to be abandoned by the Indonesian Patent Office, and it is very, very difficult to revive it in that situation. So here, we're assuming that the request for substantive examination has been timely filed, which then starts the process for the invention, your patent application, to be examined by a patent examiner. And their substantive examination report or office action will be issued, and you'll have 3 months to respond. There are extensions available, but these extensions must be filed. They're not assumed. You're entitled to a 2-month extension and then an additional 1-month extension. So you basically have about up to 6 months, but again, your local agent may charge you for filing extensions. So to the extent that you're able to respond within that initial 3-month period, you can save a little bit of cost there. If no response or extension is filed, the patent will be considered to be abandoned by the patent office. And again, it's very difficult to revive and it's costly. So, you know, as many of you may know, within the patent application process, there's a lot of deadlines. And in Indonesia, they take the deadlines pretty seriously. And so if you are going to miss that initial 3-month deadline, you need to file an extension or your patent will be considered to be abandoned. Now, with that examination report, the Indonesian patent examiner will often base their result on the written opinion of your patent application that was issued by the ISA, which is the International Search Authority. So this is relevant for PCT filings. So as part of the PCT process, you need to submit your application to an ISA, and they will issue an initial written opinion. That is almost always, or very often, the basis of the first office action issued by the examiner in Indonesia. Now, the second point is that you can expedite the examination by responding to the office action and letting the examiner know that you've already had a related patent granted in another jurisdiction. Now, the most common and the most persuasive jurisdictions that you could have are the US, EU, Japan, China, South Korea, and Australia. But there are some other jurisdictions that have been allowed. Russia is one, Germany. So, you know, again, this is not an exclusive list. This is just in the list that's most common. So in this circumstance, basically, you're telling the examiner that this patent has been granted by, for example, the United States Patent Office. And but there were some amendments that were filed. And so you will then tell the examiner that, look, a related patent was granted by the USPTO in a slightly different form. We are now amending the claims in Indonesia to match those claims that were granted by the USPTO. And now we ask you to now grant it in Indonesia. And in almost all cases, the examiner will agree with the request for corresponding and will grant the application, and it will greatly expedite the whole process. So right now, if we get an office action and we respond to it, we will, by corresponding, if we respond to the office action by corresponding to a granted patent in another jurisdiction, we'll most likely receive the notification of grant within a few months, and then the patent certificate to follow a few months after that. So it really speeds up the process, and to the extent that it's available, it's highly recommended. So a couple more things I just want to talk about as part of this patent prosecution process. There's a couple other programs or options you might have heard about. One is called the Patent Prosecution Highway. This is basically a work sharing agreement between patent offices. There needs to be a formal agreement in place, and the idea is to increase efficiency and reduce redundancy in the work by, sharing that information that was done by one office with another office, and they just assume it to be correct. For Indonesia, the only agreement they have is with the Japan Patent Office. So that means that it's really only applicable for Japanese applicants or for non-Japanese applicants who have a favorable written opinion from the Japan Patent Office as the ISA, as the International Searching Authority. So I think for this group, perhaps it's not so relevant. Another option is to request participation in the ASEAN Patent Examination Cooperation Program. So this is similar to the Patent Prosecution Highway, but it's only for 9 of the ASEAN member states, not Myanmar. And again, the idea is to share search and examination results and to increase efficiency. So far, we haven't seen any great benefit to using the ASPEC program as opposed to just the normal corresponding claim process that I was describing in the previous slide, where again, you would just tell the examiner that your patent has been granted in the US or in Japan or something like that. So again, I don't really see much benefit at this point in using the ASPEC program. One other thing to talk about, it's not directly related to patent prosecution, but I still think it's relevant to bring up, is freedom to operate opinions, or FTOs as they're called, or non-infringement opinions. This is basically a situation where you, as the owner of a product, you want to start manufacturing that product in Indonesia, you want to start selling it, you want to start importing, you want to start using that product in Indonesia. You don't hold a patent over it, or maybe you do, but you don't hold a patent over it in Indonesia. And so you want to conduct your due diligence to make sure that your use of this product, your sale of this product, your importation of this product into Indonesia will not violate another party's patent rights. And the way that you would normally do that is to hire a law firm to do a freedom to operate opinion, and they would search, all the available patents that have been granted in that jurisdiction and compare the claim set of those granted patents that are directly relevant to your patent or to your product. I'm sorry, to your product, and then give you an opinion, a legal opinion about whether or not it infringes and whether you should feel comfortable or legally safe to use your product in that country. For Indonesia, the first part of that is really, really difficult, which is conducting the searches to identify that list of patents that would be relevant. There's no publicly available database that we can use to do the searching. Instead, we have to rely on the Indonesian Patent Office to do that search. So if they come back and they get 8 out of 10 results, we don't know that they missed those 2, right? Because we don't have access to their database. We just have to rely on them to do it. So it's a very difficult thing to do. What's much easier to do is to do specific searches using certain bibliographic data. For example, looking for all patents that have been granted in Indonesia for a certain competitor. Or if you've done a freedom to operate opinion in another jurisdiction, you might be aware of certain PCT applications or certain applications that use the Paris Convention in other jurisdictions. We can search for those here using those specific numbers. And so again, that might be a more efficient way to conduct a freedom to operate search. But otherwise, to do a full search, it is still quite difficult. So we're going to pause for the second poll question.
Yeah, thank you, Andrew. We are going to start the poll now. and is going as the first time to be open for around 40 seconds. Please, I invite all the attendees to vote. Okay, we are going to close the poll now, and we will show the results. Okay, so what is the best way to expedite the examination of patent application in Indonesia? The 44% of our attendees thinks this correspond to related patent granted in another jurisdiction. The 33% goes with the PPH, and 22% to the ASPEC program. So Andrew, do you want to comment? Do you have any comment?
Sure. I think to the extent that the applicant is based in Europe, I would most likely say that the best way to expedite the examination of the patent in Indonesia is B, to correspond to a related patent granted in another jurisdiction. The reason for A is that most likely the applicants based in Europe would not be eligible to participate in the patent prosecution highway program. As of right now, it's only possible with Japan at the current moment. For C, we haven't really seen, for the ASPEC program, we haven't really seen any great benefit to using the ASPEC program so far, because it's relying on examination reports from Southeast Asia predominantly. And so at this time, it's really focused instead to look at B, which would be for a related patent in another jurisdiction, which would most likely be one of the 6 that I've talked about, which would be United States, EU, Japan, South Korea, China, and or Australia. Those would be the major jurisdictions that would be beneficial for expediting examination by using a granted patent in one of those countries.
Okay, it's a very interesting clarification, but I see that our attendees are very good at answering, so I'm pleased. So we can go back to we can stop showing and we can go back to close the presentation.
Great, so I'm moving on to enforcement here, which is basically a situation where you already have your patent granted in Indonesia, so you've been given certain monopoly rights essentially over your invention in Indonesia. And how can you enforce those rights? And I would say generally enforcement in Indonesia is difficult. It's possible, but it's difficult. And it becomes a little bit more difficult for patents. And I think that there are a few reasons for that. Primarily though, I would say that there is a low understanding or even awareness of patent and patent law in Indonesia generally. And I think that would apply to the officials of authority that would be involved in an enforcement case. So for example, the police or judges or a prosecutor, all of those individuals are unlikely to have any exposure or training with regards to patent law. Additionally, they would be very unlikely to have any exposure or training or any educational background specific to science or technology. And so when patents can get quite technical, you risk losing your audience in a sense. And so I think that's one of the main difficulties. Enforcement is difficult for other IP rights here, but trademark, while it does have its own idiosyncrasies and difficulties, at least conceptually, trademarks can be kind of visually compared. but patents require so much on the technology and the scientific side that I think it really becomes quite difficult to explain that to someone that most likely would not have, through no fault of their own, they would not have any prior exposure to that, either from a legal or a technical standpoint. So really, you can break enforcement down to a couple of different categories. The first category I'm going to talk about is on the civil side. And this is primarily, warning letters or patent infringement lawsuits. So I'm actually going to start a little bit out of order. I'm going to start with the warning letters. And so basically, this is where you've come across this, you have your granted patent in Indonesia, and you've come across a situation where you feel like someone is infringing on your patent, and where you feel like they're not respecting your intellectual property rights in Indonesia. Now, the chance of success really depends on the counterparty, because a lot of the entities here know how difficult it is to enforce patent rights in Indonesia. And so perhaps if there are truly a bad actor, they're going to ignore your warning letter. However, there are some instances where warning letters bring this situation to the notice of the counterparty, and then a resolution that's satisfactory to both parties is found. And so warning letters generally are recommended on a, it depends on the certain situation, but because they're way cheaper than litigation and they're much more direct, generally they're worth a try. It can really, to the extent that you can avoid litigation on a patent claim, I would think that would be a good idea. So if you're able to engage the counterparty and to come to some sort of privately negotiated agreement that's satisfactory to you and to them as well, that would definitely be preferable than going to court. Now with court, that's what we're talking about. We're talking about patent infringement cases, and in Indonesia, patent infringement claims are very rare. There's a lot of reasons for that. I think primarily what I mentioned above, but at the same time, even if you're able to convince a judge of the infringement that took place based on the technical or the scientific grounds, it's difficult to prove damages. There's no statutory damages provided in the patent law or in other laws that would be applicable. And you have to basically rely on a very basic calculation of actual loss. And you have to be able to prove that actual loss or an artificially reduced price. And that can be very difficult. And so even if you do that, let's say, so you're able to convince the judge about the infringement of your patent, you're able to prove your damages, and you get a judgment for $5,000 US. You then have to try and collect it. And that can be difficult as well if you're trying to collect that against an Indonesian entity in Indonesia. And so I think for all those reasons, it's why patent infringement cases have been quite rare in Indonesia. We did a survey of all the patent lawsuits that have been brought in the past 5 years, and I think it was about 33 cases, and only two related to patent infringement. The others were appeals. It's part of the appeal process for a rejection of a patent application, or there were some patent revocation cases where another party came in and said, hey, this patent really should not have been granted. And so where you have a patent infringement claim litigated into the court is quite rare still in Indonesia. On the criminal side, what we're basically talking about is raids. And the raids would be carried out by the police or PPNS, which is the investigative unit of the IP office, or for certain types of goods like food, drugs, cosmetics, it would be done by the Indonesian FDA, the Food Drug Agency, which is called BPOM. And so in each of those situations, they are complaint-based. So what that means is that the patent owner needs to file a formal complaint backed up by evidence with that respective unit. So for example, the police. And this is where the prior investigation is really important, because you want to submit as complete a dossier as possible. You want to give the police 100% of the evidence to the greatest extent possible, so that all they're left to do is just sort of confirm everything that you've already done for them. You don't necessarily want to leave them in a position where they have to go and do their own investigative work, because it slows down the process. So instead, it's better to have evidence of the infringement, know who the counterparty is, and be providing all the different types of evidence that could possibly be required as part of a dossier. I think that's really the best way to sort of move a criminal enforcement matter forward. Now, the success of a criminal enforcement matter really depends on the goals. What do you want to get out of it? Do you want the goods to be seized and destroyed? Okay. Do you want money, damages paid by the counterparty in order to perhaps self-fund your enforcement program? Or perhaps you want a public apology printed in a newspaper, or perhaps you want a signed undertaking by the counterparty that they will not do this again, and that if they do, they agree to pay damages in, X hundreds of dollars per day. It really depends on what you want. I would say that the more attainable would be the seizure and destruction of goods and perhaps the signed undertaking. If that's your definition of success, I think the chance of success could be good. Obviously depending on each of the cases. But if you're looking to get damages paid by the counterparty or you want a public apology, I think that those are more difficult to obtain. And so it would be in those situations where perhaps the chance of success might be lower and it would be more difficult to get that. And of course, if you're not able to agree on any of those things and the police are confident in the dossier, they will forward it. They will close their investigation and they will forward it on to the public prosecutor for a criminal prosecution. Just want to briefly touch upon preliminary injunctions. I know that in Europe or in other jurisdictions, they are a very viable option. In Indonesia, they remain theoretical at the present time. Given, let's see, counting from 2012, which is when the Indonesian Supreme Court first issued the regulations for preliminary injunctions for an IP right, there's only been one application for a preliminary injunction for an IP right granted. And that was on a copyright case brought by the daughter of Indonesia's first president. So I think maybe that gives you an idea of the type of applicant that would have to bring a claim in order for it to be successful. And actually, it was actually overturned on appeal by the Supreme Court. So this is a very new area of the law. It hasn't really been tried out. And I think what we've heard is that there might be some new regulations coming later in the year because the Supreme Court is interested in making this a more practical option and less theoretical, and so they're going to issue some revised implementing regulations. And so we'll have to kind of watch and see what happens with this. But for right now, it's not that practical an option, I would say. So the next thing is patent annuities, and so this is a situation where you have a granted patent, and annuities are basically rent. Right? So if you have a patent granted, you have been given a monopoly right by the government for 20 years. And every year you have to pay rent back to the government for that monopoly right. In Indonesia, this might be familiar to some of you who have already granted patents in Indonesia. This issue has been quite controversial, but basically under the old patent law, if you had a patent where you did not pay your annuities for 3 consecutive years, your patent would be considered to be abandoned. That's fine, okay, but the problem is the patent law, the old patent law, said that even though it became abandoned, those unpaid annuities for those 3 years were still considered a debt owed to the government. And now the government is trying increasingly aggressive measures to collect on those debts. And so starting from August 17 this year, so next month, for applicants that are filing new applications and that those applicants still have debt on the books for unpaid annuities relating to other patents, those new applications will be rejected. And so that's a pretty heavy hammer to drop. And so they're really trying to force a lot of these entities to pay up. So to the extent that you have granted patents in Indonesia, it is definitely worthwhile contacting local counsel there, IP agents in Indonesia, to check in the name of your entity to see if any of your granted patents are implicated by this unpaid annuity scheme. If not, then you should be good to go, but if so, you need to address that situation immediately. Otherwise, there's a real risk that starting in August of 2019, any new application filed by you or your company will be rejected. So the last thing I'm going to talk about is another controversial topic in the Indonesian patent world, and it's called the working requirement under Article 20 of the new patent law. So This was actually included in the old patent law as well, that they never issued the implementing regulation. So basically what this is, it requires you to work your patent in Indonesia. And so that means that you either need to make your patented product or you need to use the patented process in Indonesia. And the rationale is to support technology transfer, investment, and or job opportunities in Indonesia. If you do not practice your patent, if you do not make your patented product or use your patented process in Indonesia, it means that you will be vulnerable to compulsory license, which essentially is where a third party comes in, files an application with the government and says, you have not been practicing your patent in Indonesia, and so therefore the government can force you to give permission to another party to use your patent, and they will pay you a small royalty as compensation. And so that's a real threat as well. And so basically, again, they're trying to use this hammer to get people to really start producing their products and to manufacture their products in Indonesia. So what that means is that there's a deadline, and the deadline is coming up. And so for patents that were granted, not filed, but granted before 26 August 2016, the deadline is 26 August 2019. For patents that were granted after that date, after 26 August 2016, the deadline is 3 years from the Indonesian grant date. You have a 3-year grace period. After that time, if you are not using your patent, you then become vulnerable to this compulsory license. However, you can apply for an extension, and these are part of new government regulations which have just been issued in the past few months, and they're a little confusing and there's not a lot of detail, but basically there's an extension scheme which allows for an application up to 5 years, and it needs to be based on an acceptable reason. So some of the reasons that we've heard informally are that it's not commercially viable to practice the patent in Indonesia because it's not on the scale necessary, or that the patented process is still being perfected, or that the product is still in product development. There are some pretty general reasons that are available, but if you're not using your patent in Indonesia and you're coming up on that 3-year deadline after the grant date, you need to apply for an extension. If you are using your patent or the patented process or product in Indonesia, then there's nothing that you need to do affirmatively. You can just wait. And so then if someone filed this sort of request for compulsory license, you would then need to prove that you are using this patented product or process in Indonesia. But you don't need to do anything other than that. So again, if you're using your product in Indonesia and you come up on that 3-year deadline, you don't need to worry. It would only come up in a circumstance where someone is challenging that. So that's all I have for today. I think we're going to pause now for question and answer. So if anyone has any questions, please let me know. But let me just take the quick opportunity to thank you all for listening. I really appreciate it. I hope it was useful and helpful. Thank you.
Thank you, Andrew, to this very interesting and I would say very clear presentation. We now open the floor for questions. So if you have any, you can type in the box in your control panel. Meanwhile, we have already a couple of questions actually. The first one is asking if it's possible to patent a software in Indonesia.
Sure, it's a good question. So basically, under the old patent law, it was clear that the answer was no. Under the current patent law, which came into effect in 2016, the answer is a little bit more nuanced, I guess we could say. So the new law says that rules and methods that only consist of a computer program are not allowed. So that means that they're not patentable. However, if you have a computer program that has a technical effect or function in order to solve a problem, that could be allowed. And that would be a situation where having a grant from another jurisdiction for that type of computer program with a technical effect would be very helpful. and that would really sort of expedite and smooth the examination process. But if you just have a proper computer program without any such technical effect, most likely it would not be allowed to be patented in Indonesia. The patent law gives two examples of what might be allowed, and they're pretty basic, but one is a computer program algorithm, right, that has a technical effect, or an encrypting, a process for encrypting information, right? So that would also have a technical effect. So those are the two examples in the patent law that are identified as computer software programs that would be allowed under the current patent system.
Okay, thanks a lot. And then there is another question that regards patents in general. So the question is if a patent has to be new, but what happens if I show it in a trade fair? There is any kind of exception for trade fairs to the strict requirement of newity of the patent, or is advisable never to show something in a trade fair in Indonesia if you want to patent it, or somewhere else?
Sure. So yeah, as Marta mentioned, one of the main requirements for patenting an invention is that it's new, or novel is the term that is used a lot, that it has to be novel. And that's a really high standard. And so basically your patent has to be brand new, taking into account everywhere in the world, anything that's ever been done. Basically, that's the standard. And so obviously there are trade shows and there are exhibitions and there are other things where you might want to show your patented product or process before the application has been filed. And in Indonesia, there is an exception to the novelty requirement, which says if you disclose your invention before you file an application as part of an official international exhibition that's either inside Indonesia or outside Indonesia, you have 6 months, basically, to file an application from the date of disclosure. So as long as you file your application within 6 months, your patent will be sort of, I guess, grandfathered in. It will be given an exception to the fact that it was disclosed before the application was filed. There's also an exception that's similar to an inventor who comes to Indonesia to experiment with their invention for R&D purposes. And so again, if they file an application within 6 months of the disclosure, it will be allowed and it won't destroy the novelty requirement.
Okay, so thank you. It's very interesting. I don't see other questions, so I will just repeat for everyone that you can always submit us questions later via our website or our email address. The recording and the PPT of today's webinar is going to be available on our website. And again, I want to thank you, our expert, to participate today with us and for this very interesting presentation. So goodbye to everyone, and thank you again, Andrew, for being here. Thank you.
Thank you.